Greetings, everyone. I'm Advocate Pule Matselo. If you are new to this channel, the purpose of this YouTube channel is to teach South African law, but also to preach the Word of God. I want to say thank you very much to all those who have subscribed, to those that are commenting, and to all those who have shared my YouTube channel. If you haven't subscribed, please do consider to subscribe. Today, I'll be teaching on the law on interstate succession in South Africa. What is interstate succession? The main question that I want to respond to is, what happens to your property when you die, when you pass on without a will? This is why we're talking about interstate, because you do have an estate, but you did not draft a will. So the procedure that I will outline here is what happens to your property, to your estate, where there is no will. Where do we get our guidance from as to how to distribute your property? What I'm going to discuss here is regulated by Intestate Succession Act. It is that act that outlines what is it that should happen. I must also hasten to mention that it is not advisable that you should die without having drafted a will. And also, I need to hasten to mention that if you have drafted a will, it does not automatically mean that your estate will be taken care of in terms of that will. Reason being, that will can be challenged. One of the reasons why it can be challenged, it's because it does not meet the requirements of a valid will. So there are certain requirements that should be met for your will to be recognized, for it to be taken seriously, and for your asset or for the deceased, the one who has passed on, for his or her asset to be distributed in line with what he or she has said in the will. Because it is very important that his estate should be distributed the way he or she deemed it fit. We can't just do any other thing except for what is mentioned in this valid will. So the key thing is that there must be a will, but if the deceased did not prepare a will, we will apply this law that I've just mentioned. And then secondly, it must be a valid will. Now, we want to look at what is it that will be done, or how will his estate and or property be distributed. Number one, if this person was married and there is no will, his estate will be distributed among his wife, or let me say among his spouses and children. If he had one spouse, obviously, it will be distributed between the spouse and the children. If he had spouses, it will be between spouses and children. If he did not have a spouse, he has children only, maybe their spouse died before them, it will be distributed among his children. If he does not have children, it's only a spouse, his property will be given to the spouse. And if there are spouses, they will also be taken care of. They will also receive part of his estate. And going back to the issue of children, children here means legitimate, illegitimate, and adopted children. They will all be treated the same. We will not say to these children that, no, you were born out of wedlock. No, that's not how it works. Children are children, and all children will receive equal share. And there's a way in which this property will be distributed. The calculation there, I will not get into details. Taking into account that this is just legal education, it's not a legal opinion. So please, you will still need the services of an attorney to go about dealing with the estate of the deceased as a beneficiary. So mine is just legal education. So there's a way in which they will calculate. It's not up to you. There's a way in which the master of the Supreme Court, of the High Court, will calculate and distribute the assets. And also, one of the things that will be considered in distributing these assets will be whether these two, if it's a husband and wife, whether they were married in community of property. That will also be one of the factors that will be considered when they calculate and when they divide the assets. Now, in a case where, say for example, the deceased is a father or is a man, in a case where he had 3 children and one of them passed on before him, and this 3rd child who passed on had children, what will happen is his children, the child who passed on, his children would share from the portion that was meant for him. In other words, just as an example, the figures are not necessarily like that. You have a wife, we have 200,000, it's just an example. The wife will take 50, the 2 children will take 50-50, and then the fourth 50 will be distributed among the children of the deceased child. Now, if this man, the man is our example here, he passes on, he doesn't have a wife, he doesn't have children, his estate will be given to his own parents. If it's a wife, the wife estate will be given to her own parents. If they don't have parents, this inheritance will be distributed amongst his siblings. That's as far as I can go. But the most important thing to notice is that there's no way the inheritance of a man or of a woman will be given to his parents when he has a wife, when he has children. That's not how it works. It starts with the wife and the children. It's then that if there's no spouse, if there are no children, it now goes to the parents, it now goes to the siblings. The most important thing also to notice is that a person who is supposed to be a beneficiary but has killed the disease is automatically disqualified. This person will not benefit from the death of the deceased because he caused this death after all. Another issue which they consider is repudiation, reject. If, say, he had 3 children in our example again, and the 3rd child says, I don't want his inheritance, I don't want her inheritance, his share will be given to other children because he does not want. It will not be imposed on him. Now, the next part is who handled the inheritance. Once this person has passed on, the beneficiaries of the inheritance, the beneficiaries of his estate, they must approach the master of the High Court with the necessary documents. The necessary documents here will include them submitting a notice that this person has passed on, submitting the death certificate, submitting their IDs as beneficiaries to the estate, And all other documents as they will be guided by the attorney who will be assisting them with this matter. Now, before the inheritance is paid, or before the distribution of the estate, the Master of the Supreme Court must consider whether there are creditors. So the death of the deceased, of the person who has passed on, must be paid first. The creditors must be paid first, if there are any, before the distribution of the estate. There will be instances where the estate is actually insolvent, in the sense that this person owed, and after the creditors are paid, there's nothing left. In that case, they will not benefit anything, because clearly there will be nothing left for them to be paid. The other thing that I need to mention is, if a person has a will and there are some things that he did not mention in his will, because you must remember that here we are talking about a situation where somebody did not draft a will at all. But in a case where he had a will and he omitted or he left some of his property, some of his estate outside the will, he did not mention them. Maybe he had 2 houses, he only mentioned 1. Maybe he had 3 cars, he only mentioned 2. The ones that were not mentioned in his will be treated as if they are interstate, and they will be dealt in terms of the Interstate Succession Act. They will be distributed. These particular ones that were not specified in the will, they will be treated as if for that moment he did not draft a will. So they will be distributed in line with the principles that I have just outlined as contained in the Interstate Succession Act. I hope this helps a lot, but this is just to encourage people that please go out, draft your wills, make sure your wills are valid, and once you have drafted that will, from time to time revisit it. But that discussion will be for our next lecture when we talk about testate succession. It will be in a case where somebody had drafted a will. But today we were addressing a situation where a person did not draft a will. I thank you. I hope this was helpful. I know that it is not much. It's just little education that I want to share with you at the moment. But please do subscribe and comment and share this video so that people can access this information. Thank you very much. I'll see you next time.